This is Bloomberg Law with June Grasso from Bloomberg Radio.
Welcome to the Bloomberg Law Show. I'm June Grasso. Ahead in this hour, Donald Trump lashes out at a New York judge. A D.C. appellate court appears skeptical of his presidential immunity claims. The Supreme Court takes on the no-fly list. And a Russian billionaire sues Sotheby's over 4 masterpieces.
Could a president order SEAL Team 6 to assassinate a political rival? That's an official act in order to SEAL Team 6?
He would have to be and would speedily be, impeached and convicted before the criminal prosecution.
What if he weren't? There would be no criminal prosecution, no criminal liability for that?
What the founders were concerned about was not...
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is no.
And it seemed to go downhill for Donald Trump after that question was pressed repeatedly to his attorney by Judge Florence Pan at Tuesday's D.C. appellate court arguments. All 3 judges on the panel seemed highly skeptical of Trump's claim that he's immune from criminal prosecution for trying to overturn the 2020 election because he was president at the time. As Trump looked on from the audience, his attorney, John Sauer, tried to convince the judges of the Pandora's box of horribles if presidents don't have absolute presidential immunity. But Assistant Special Counsel James Pierce pushed back against that claim.
The notion that criminal immunity for a president doesn't exist is a shocking holding. It would authorize, for example, the indictment of President Biden in the Western District of Texas after he leaves office for mismanaging the border, allegedly.
Never before has there been allegations that a sitting president has, with private individuals and using the levers of power, sought to fundamentally subvert the democratic republic and the electoral system. And frankly, if that kind of fact pattern arises again, I think it would be awfully scary if there weren't some sort of mechanism by which to reach that criminally.
The judges also seem to completely discredit Trump's argument that a president can only be criminally prosecuted after Congress has voted to both impeach and convict him on similar charges. Here's Judge Michelle Childs.
But not everybody goes through that process. And of course, it's limited to the certain actors in that regard, but not everybody has to go through that process. Prosecutors later on can come into information and evidence after they've investigated to make their determinations about what they'd like to criminally prosecute. So you're not always confined to whatever would be in the impeachment judgment clause.
My guest is Michael Gerhardt, a professor at the University of North Carolina Law School. His new book is entitled The Law of Presidential Impeachment. It seemed like the focus of the argument for Trump's lawyer was that under the Constitution's impeachment clause, a president can't be prosecuted unless he's first impeached and convicted over the same charges. Tell me about that argument and what you think of it.
It's really dumb, and it's not a good argument. There were 3 judges in the late 1980s that all faced impeachment, and all 3 were actually tried criminally before they were impeached. And they raised that argument back in the late 1980s, and courts rejected it. There's no constitutional requirement that impeachment precede a criminal investigation or that a criminal investigation precede an impeachment. They're separate proceedings. It's just that simple.
So then where did they get that argument? Did they make it up out of whole cloth?
I think they largely made it up. I think it's designed in part to delay things. That's first. Secondly, and this might be the best characterization of it, it might be loosely based on some constitutional language that seems to leave an inference after an impeachment that officials could still remain liable at law. But that's not a command. That's just basically suggesting that after an impeachment, there could be separate legal proceedings. I would also maybe suggest third, that I think it's just another variation of Trump's arguments, which date back to his presidency, that he, apparently no other president, but he at least is above the law.
That led to some really startling hypotheticals. Judge Florence Pan asked, if a president ordered SEAL Team 6 to assassinate a political rival, could he be criminally prosecuted? Over and over again, she tried to press him, yes or no, yes or no. But he didn't even make a concession there. So we're left with the outrageous suggestion that a president can assassinate a political rival and not face prosecution.
Well, I think that he was, in a sense, arguing from a corner, so he was already backed in. And I think he thought maybe his best option was just to take a hard line. But I think that question, among others, sort of underscores the absurdity of Trump's argument.
Did you see any inkling that any of the judges were buying that particular argument?
I did not, but that may not mean very much. There's not always a complete overlap between what happens in an oral argument and what comes out of an opinion. So lawyers tend to take with a grain of salt all the questioning in an oral argument because lawyers understand it may not necessarily lead to or predict exactly what the opinion might look like. But I think before there was any argument, I and other scholars who sort of study this area thought Trump's arguments were probably at best weak, if not absurd. And I think that the judges at least appear to have so far taken a similar sort of approach.
There was one thing that one or two of the judges picked up on. Judge Karen Henderson expressed concern that a ruling saying the president doesn't have immunity would lead to politically driven prosecutions of future presidents.
How do we write an opinion that would stop the floodgates? Your predecessors in their OLC opinions recognized that criminal liability would be unavoidably political.
Which side had the better of that argument?
Well, I think that question really has been answered already by the United States Supreme Court. They answered it in a case called Trump versus Vance. And in that Supreme Court case, the Supreme Court ruled that a president, in Trump's case then a sitting president, may be subject to state criminal prosecution. Trump tried to argue in that case, the president could then be subject to all sorts of partisan prosecutions. And the Supreme Court rejected that because the court said there are all sorts of safeguards against that. So it's not really going to be a real or practical concern because if that's the motivation, if it's in federal court, federal judges could obviously try to look behind it, but so could state judges. And ultimately, a state prosecution of somebody, let's say, who used to be president is still possibly appealable to the United States Supreme Court, which is a whole other safeguard that could exist. So there's no reason to think that the possibility of a partisan prosecution means there may never be a prosecution.
So what's your best guess of how the panel will rule? And by the way, I want to mention that this was an all-female panel of judges, a refreshing change, consisting of 2 Biden appointees and 1 George W. Bush appointee.
I think that the court has to be thinking, among other things, about what kind of precedent are we going to establish here. And if I had to guess, my guess would be that the court's going to not want to establish a precedent that makes it easier for presidents to be above the law. The bottom line is Trump's going to face criminal trial, and he can't avoid that.
And so Trump's lawyer asked for a stay of the opinion so that they can appeal. So if they appeal to the full D.C. Circuit, ask for an en banc hearing, do you think the D.C. Circuit would take that en banc?
Well, I don't know the answer. I'm not sure why the full D.C. Circuit needs to hear this. I think that's another move by Trump's lawyers to delay everything, sort of to throw a lot of legal process at the proceedings against him as a way to kind of delay them in the hopes, I suppose, that Trump will win the presidency and pardon himself, or that one of his acolytes will win the presidency and pardon him. But the courts, I think, are aware of the possibility that they're being used here. And generally speaking, courts don't like to be used in that manner.
Everyone assumes that this is going to be appealed to the Supreme Court no matter what happens. And a lot of legal experts are predicting that the court will take the case. But is that necessarily true?
No. Let's say, for example, this current panel concludes that none of Trump's arguments are credible and the court rejects all of them. The Supreme Court could simply reject any appeal based in part on the justices considering there's no real issue here. We have to decide because what the panel would have concluded is consistent with whatever courts have said before. So there's no compelling reason why the U.S. Supreme Court needs to intervene at this point. The other thing I might just raise at this point is to just make note of the fact that Trump is still trying to argue that as a former president, he has some kind of special immunity. The sitting president may not be immune to criminal process. That was decided by the U.S. Supreme Court when Trump was president. That's Trump versus Vance. So these are quite long reaches. Donald Trump is claiming for a former president immunity that, by the way, no sitting president has ever had. And that just increases the odds, I think, that courts will reject his claim.
And the decision from this panel could come at any time. Thanks so much for your insights, Michael. That's Professor Michael Gerhard of the University of North Carolina Law School. Coming up next, Trump also made an appearance this week at his New York civil fraud trial, where he lashed out at the judge. I'm June Grasso, and this is Bloomberg.
Well, see, my legal issues, every one of them, everyone, civil and the criminal ones, are all set up by Joe Biden, crooked Joe Biden.
Donald Trump even blames the civil cases against him on President Joe Biden. And at the finale of New York's $370 million civil fraud trial against Trump, a trial in which his business empire is at stake, the former president repeated his list of grievances and lashed out at the judge. Joining me is Bloomberg legal reporter Patricia Hurtado, who was in the courtroom. Pat, Trump was not supposed to speak at the closing arguments on Thursday. What happened to change that?
Email exchanges began last week between the court, the AG, and Trump's lawyers, suggesting that Trump wanted to speak. And number one, the AG's office is flipping out that there's no precedent for a defendant to help deliver their own closing argument. And that's not proper. And then the judge was saying, is your client willing to follow the rules, which are no political speeches, basically, stick to the facts and the evidence that you're arguing. And the judge gave him multiple deadlines. And at one point, the judge was saying, you've got a drop dead deadline. You have to tell me if he's going to speak on Thursday. And then Trump's lawyer says that Melania's mother passed away, so he'd like to postpone everything till the 29th of January. And the judge is like, no, you can't. And then Trump's lawyer says, basically, it's very unfair, Your Honor, to do this, not allowing President Trump, who's been wrongfully demeaned and belittled by an out-of-control, politically motivated attorney general, to speak about the things that must be spoken about. The judge said, I won't debate this again. Take it or leave it, now or never. You have until noon, 7 minutes from now. I will not grant any further extensions. And that last sentence, I will not grant any further extensions, was all in caps. And then the judge messages back, hey, it's 12:12 now. I never heard from you. So I assume that your client will not agree to the reasonable, lawful limits that I have imposed as a precondition to giving a closing statement. Because, we all know the rules. Parties not supposed to be speaking in court. So Trump's lawyers, 3 of them, gave closing statements. And they finished. And then one of his main lawyers, Chris Kise, turns to the judge and says, I know you said that my client couldn't speak, but now could he speak? He'd like to speak. And the judge is like, well, will he abide by the rules I set? Will he promise to do that? Mr. Trump, do you promise to do that? And then Trump didn't even answer him, just launches into, yeah, I'll abide by the ground rules. And he just starts speechifying. And it's going on and on and on. And he spoke for about 6 minutes in a diatribe against the AG, against everyone that was unfair to him, about the judge.
And we should point out that the judge is the one that's going to be deciding this case. There is no jury, yet he's been attacking the judge.
He accused the judge of not paying any attention. He said the judge never listens for more than a minute anyway. And so he said things like, these days and months and years and millions of pages, they've found nothing. And for what? I borrowed money from the bank, much smaller than $370 million. And then that's when the judge interrupted and he goes, just one more minute. And then he goes, you can't listen for more than 1 minute. They should pay me for what I've gone through. And then the judge says, okay, thank you very much. Mr. Kise, can you please control your client?
The New York AG claims that Trump inflated his assets for more than a decade to get better terms on hundreds of millions of dollars in loans. How did Trump's attorneys defend against that in the closing arguments?
It's a whole witch hunt. It's everything improper. If anyone made any mistakes, it's all Mazar's fault. It was always mistakes were made, but they're not important and material. No one was harmed. The banks weren't harmed, stuff like that. It's been the same exact thing this whole time.
And the judge says he'll aim to deliver a verdict before January 31st. Thanks so much, Patty. That's Patricia Hurtado, Bloomberg legal reporter. Trump used his 2 court appearances this week to rail against the 6 cases against him, 2 civil cases and 4 criminal cases. and he wasted no time on Tuesday spreading the word that Fulton County prosecutor Fani Willis has been accused of misconduct in the Georgia election interference case.
They say she's in far more criminal liability than any of the people she's looking at. So I think that when you look at what happened where they pay a lawyer with absolutely no experience $700,000 who happens to be her lover or her boyfriend, and then they go on trips and vacations together, very expensive vacations together. And the reason they paid him so much because he was after me.
Trump, of course, embellished and distorted the allegations which come from a court filing in the case. One of his co-defendants, Michael Roman, a former Trump campaign official, claims that Willis improperly hired her romantic partner to lead the RICO case and benefited financially from his appointment. The filing does not offer any direct evidence to back up those claims, and Willis has not yet responded to the allegations. Joining me is Michael Moore of Moore Hall, the former U.S. Attorney for the Middle District of Georgia. Michael, how damaging are these allegations that Willis hired her romantic partner, Nathan Wade, to be the special prosecutor in the case and benefited when he took her on several trips to California, Florida, and the Caribbean?
Well, without question, I think it's tragic for the case. And I don't mean that it means that legally that I think that the allegations raised in Mr. Roman's motion are sufficient to have the case dismissed, but it's just an unforced error on the DA's part if they're true. And I don't know if they're true or not, but it would be hard to imagine a lawyer filing that kind of nuclear motion without having some proof in their back pocket. While I don't think, again, that it gives a legal defense, it just makes the optics terrible. And it gives the already plentiful critics of the prosecution in the case, it just gives them something else to grab hold to. And as a prosecutor, you don't want to do that.
Is there anything wrong with Willis having a romantic relationship with the special prosecutor working for her?
Well, it can be. I mean, I think there are always concerns, when you have that because of potential problems with sexual harassment and workplace problems. I imagine it is violative of probably some ethical provisions for the office. Is it illegal on its face? No. And their private life is their private life. So I don't know that really is the basis of the attack. It's more of a, was this appointment made and is this prosecution itself now being used as a way to generate funds that somehow flow back to the benefit of the district attorney herself. And I think that's the basis of their motion.
And this isn't the first time that Willis has faced public scrutiny, including an Atlanta judge criticizing her in July of 2022 for hosting a fundraiser for a Democratic candidate running against one of the potential targets of the investigation.
We've talked about this at some length, the question of whether or not an elected DA should even be prosecuting a case like this. And so just if you compare the difference, what we see in Jack Smith as special counsel versus what we're seeing in the Fulton DA's job, and that is you've got an elected official, she's moving around, making media appearances, walking on red carpets and openings and glamour things and all this. And you've got Jack Smith basically who's in a cave somewhere with his minions doing his work, and he's not coming out and making public statements and putting himself out for public scrutiny. And so while the DA may argue, well, some of this I need to do as part of my job because I have to be reelected, that seems to weigh against the value of having an elected DA involved in a case like this, and it causes the case to be somewhat tainted from an optics point of view. And I think the same is true even in the appointment of staff. As we've seen, if the allegations in this motion that have been raised are accurate, then Mr. Wade has never prosecuted a felony case. And so you have to be asking yourself, why would this be happening as opposed to having a career prosecutor who's well-versed and well-experienced in felony prosecution? Then the concerns about how much he's being paid, why is he being paid that, how was he selected? All these things start to then come together. And so while it doesn't make the case unprosecutable, it makes her job much, much harder as a prosecutor to do something and make decisions that the public can continue to have confidence in.
We'll wait to see what she says in her answering papers. Thanks so much, Michael. That's Michael Moore of Moore Hall. Coming up, getting off the no-fly list. I'm June Grasso, and you're listening to Bloomberg. This week, the Supreme Court justices faced a quandary over the government's secretive no-fly list. The justices sought to balance security and fairness in the case of a U.S. citizen who sued the government for violating his constitutional rights when it put him on the no-fly list. But the government took him off the list 8 years ago and says the case is moot or no longer a live controversy. Jonas Fikre says he doesn't know why he was put on the list in the first place and what kinds of activities risk getting him put on the list again. Both liberal and conservative justices pressed the Assistant U.S. Solicitor General, Sopan Joshi, on the black box that the no-fly list is. Here are Justices Sonia Sotomayor and Clarence Thomas.
How can someone tell you that they're not going to engage in a terrorist activity if they don't know what terrorist activity it is that you claim they did?
But we know nothing. How would he know a year from now if he is on the list with the same procedures or different facts when he doesn't know why he was on the list in the first instance?
Yeah, so that's the key. He does know why he's on the list. He was told that he was put on the list because he posed a threat of engaging in or conducting a violent act of terrorism and was operationally capable of doing so.
Justice Neil Gorsuch was one of the justices who appeared most sympathetic to due process concerns in the case.
Now, the government may very well have had good reasons. I don't for a second mean to suggest otherwise. But an American citizen normally has a right to what's been called every man's evidence against him. That's due process. That's a pillar of our democracy. And here the government says, no, you don't get that evidence.
Joining me is Hina Shamsi, director of the ACLU's National Security Project. The ACLU filed an amicus brief in the case. So start out by telling us what happened to Jonas Fikre.
Well, Jonas Fikre is a U.S. citizen who discovered that he was on the no-fly list in 2010. And he then filed a lawsuit saying that the government wrongly placed him on the list in violation of his constitutionally protected right to travel, and that the procedures that the government used to place him on the list violated fundamental due process. So the case moved forward, and the government then removed him from the list in 2016. And since then, it is argued that his lawsuit could not go forward because it was moot. There was no live case or controversy to be adjudicated. Mr. Fikre then appealed from a district court judgment in the government's favor, and the Ninth Circuit Court of Appeals twice issued decisions in Mr. Fikre's favor, rejecting the government's attempts to end the case. And that's when the government appealed to the Supreme Court, and that's the argument that the court heard.
Does the government, the FBI in this case, frequently refuse to tell people exactly why they've been put on the no-fly list or why they've been taken off the no-fly list?
Absolutely. And this is one of our fundamental problems with the no-fly list and why we've been working on litigating these issues for about 20 years, which is that the no-fly list program essentially operates in a black box of executive branch discretion and secrecy. The government refuses usually to tell people the full reasons, and most often any reason, for placing people on the no-fly list. And so for decades, we and other rights groups have documented the secrecy and unfairness of this program and its devastating consequences for people's lives, yet it remains a black box. Let me be more specific. Americans who are on the no-fly list are most often left in the dark about why they've been placed on the list. They're not given any meaningful explanation when they are removed, if they are removed, or any guarantee against being wrongfully placed on the list in the future. And the issue before the court was whether Mr. Fikre's case could go forward after he had been removed.
Does Fikre know why he was put on the list?
He does not have all the reasons that he was put on the list. In the argument that took place on Monday, the government repeatedly said, well, we've provided a reason. We've explained the criteria for placement on the no-fly list that was applied to him. But here's the problem. What that means is that the government has disclosed what standard it uses to place people on the no-fly list, and we can talk about why that standard is vague and broad and deeply problematic, but it hasn't disclosed the reasons that it thinks Mr. Fickrey satisfied that standard. So Mr. Fickrey doesn't know what he's alleged to have done wrong in the first place and how he can, as he argued to the court, know what to do in order not to be placed on the no-fly list again in the future.
It seemed as if several of the justices cross ideological lines were sympathetic to Fickrey. Justice Sonia Sotomayor said, how can someone tell you that they're not going to engage in a terrorist activity if they don't know what terrorist activity you claim they did? So a catch-22.
It is a real catch-22, and it was a concern. The discretion as well as the secrecy is something that the justices, and I think a lot of the justices across the spectrum, were troubled by or expressed concern about, because as often happens, courts as well as the people who are impacted by the placement are left in the dark in this black box of a program.
Justice Elena Kagan suggested that the government should be required to go before a judge in private to explain why someone had been placed on the no-fly list, why they'd been removed from the list, and why they would not be returned to the list. And Justice Gorsuch seemed to agree with that. Is that a possible solution here?
Well, I want to start with what Justice Gorsuch said, which is that normally in our legal system, we have a right to know what evidence the government has against us, and that's due process. So one of the alternatives proposed during the argument in court was that the government could provide its reasons to a judge in camera, meaning, in continued secrecy, for the judge to make a determination. And that would certainly be better than what exists now, or what Mr. Fickrey was facing, which is not being able to have any kind of meaningful guarantee that the government would not place him on the list wrongly again in the future. I think we should still pause and think about what that might mean, though, that the government tells a judge, but if you're a person who has been left in the dark about why you've been placed on the list in the first place, why you've been denied, as some of my clients have, the right to travel to be with their loved ones on their sick beds, to attend funerals or weddings or graduations, surely more is required to the person impacted themselves. But let's see how the court rules.
And what about the government's position that there's not an open controversy here?
The FBI's position was that they have told Mr. Fickrey that he would not be placed on the list again, quote, based on currently available information, and that is enough to end his case. And what Mr. Fickrey was arguing was that that isn't enough, that when the government acts as it did here, which is that it voluntarily takes someone off the list, the case is not moot, because the standard the government has to meet is to make it absolutely clear that the allegedly wrongful behavior won't happen again. And Mr. Fickrey argued that the government hasn't repudiated its decision to put him on the list, and it remained free to return him to the list for the same reasons and using the same procedures that Mr. Fickrey alleges were unlawful. So in essence, Mr. Fickrey was asking for his case to go forward so he could have his day in court.
And what do you think the justices might do here?
Well, I think what leaves me cautiously optimistic about the argument is that most of the justices understood that a system in which a person does not know the government's reasons for placing them on the list or taking them off it, that there's not really a guarantee here against the kind of wrongful conduct that is being challenged occurring.
Thanks for being on the show. That's Hina Shamsi of the ACLU. Coming up, a Russian billionaire takes Sotheby's to court over 4 masterpieces. I'm June Grasso, and you're listening to Bloomberg.
And so, ladies and gentlemen, we move to the Leonardo da Vinci, the Salvator Mundi, the masterpiece by Leonardo of Christ the Saviour, previously in the collections of 3 kings of England.
And in that auction, billionaire Russian oligarch Dmitry Rybolovlev resold Salvador Mundi for more than triple the amount he paid for it. Now that painting and masterpieces by Modigliani, Klimt, and Magritte are the subject of Rybolovlev's suit against Sotheby's. He claims the auction house helped a Swiss art dealer dupe him out of more than $230 million when the dealer bought artworks through Sotheby's and then turned around and sold them to Rybolovlev at markups worth tens of millions of dollars. Sotheby's denies any wrongdoing. Joining me is Bloomberg legal reporter Chris Dolmesh, who's covering the trial. Chris, this case offers a glimpse into the opaque art world.
It's interesting. This is the art world, and it's kind of inherently secret just in the way it operates. Maybe some of our listeners might see the parallels to, say, bond trading and things like that, where there's no central exchange that you can look up the prices of a Picasso or a Da Vinci. You know, it undergoes an evaluation process by auction houses like Sotheby's and by private actors, and often some of the participants don't really want to have their identities out there at any point in the process. They just want to sell the work. So therefore, it can lead to this kind of opaque market where you don't really know what the true value of a work is until, somebody buys it. I mean, that's really the true value of it, is somebody's willing to pay a certain amount of money for the work. And that has led, through the years, there's certainly other cases where collectors have felt that they were misled by dealers as to, how much they paid for something like that. But this case is really at the high end of the art market. And we're talking about a Da Vinci that was the most expensive artwork ever sold. And needless to say, you don't often see Russian billionaires on the stand in federal court in New York. So that alone makes it a fascinating case. And to kind of have just the art world laid bare for an audience in federal court.
So tell us what Rybolovlev's claim is.
So he claims, and he's claimed all along, that this was a massive fraud hoisted on him by Yves Bouvier, who was his art dealer for many, many years, and who was arrested in 2015 as he was going to the billionaire's apartment in Monaco, thinking he was completing a deal for a Mark Rothko. And instead he was arrested, and it's been almost a decade of various legal maneuvers. The dealer and Rybolovlev have settled late last year, so that he's no longer involved in the case. But essentially he alleges that the auction house helped the dealer kind of mislead him into these deals by providing documents that supported the valuations that he claims were excessive and allowed the dealer to pocket, more than $1 billion in improper payments that he wasn't aware of being paid. Essentially, he says, that he would just buy these things in private, pretend he was negotiating with the sellers, and then just sell it to him while making up a whole line of talks about acquiring the painting.
It seems like it's odd for the jury to see him suing Sotheby's when the man who's at the heart of this is not in the courtroom.
For sure, and that's what Sotheby's is hanging its hat on here. They say, this is a billionaire. This is a guy who does regularly large transactions, buys a lot of art, owns the Monaco soccer team, and should have done his own due diligence rather than relying on the statements of an art dealer who one could easily suspect might have a different interest.
And Bouvier's lawyers point to the fact that Rybolovlev did not win the legal actions he brought against Bouvier in jurisdictions around the world. And also, federal prosecutors were looking into Bouvier and dropped the case.
Yes, the prosecutors here in the Southern District of New York had spent more than a year building a case against the dealer. But then after Rybolovlev sold the Da Vinci work for the record amount, $450 million, more than triple what he paid, they dropped the probe, saying that there was no real way that they could prove criminality.
It sounds like it'll be a fascinating case. Thanks so much, Chris. That's Bloomberg legal reporter Chris Dolmesh. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.